Hi everyone, and welcome to our PowerPoint on the tort of negligence. Negligence is the largest category of torts, and it's really the category that we think of when we think about cases involving slip and fall. You know, somebody that was walking through a grocery store and slipped on a banana peel that he didn't see, falls and hurts himself, maybe breaks his leg and has to miss some work, and decides to sue the grocery store for those injuries. That all falls under the tort of negligence. And we probably know the word negligence just from our everyday lives. To be negligent usually means to be not paying attention to something, and that's really where it stems from. So let's talk a little bit about what is the tort of negligence. It's the tort that allows one party, and of course that would be the plaintiff, to recover damages, meaning money, based on the wrongful acts of another party. So one party, in this case it would be the defendant, makes a mistake, acts wrongfully, and that causes injuries to a plaintiff, and we recognize that in a court of law that injured party, the plaintiff, can sue the defendant to recover his damages that were caused by that defendant. So just to go over some of the terms, remember the plaintiff, this is the person in a civil lawsuit who has been injured and who brings the lawsuit against the defendant. So the defendant being the person or the party alleged to have done some wrongdoing, maybe is the one who left the banana peel on the floor, didn't clean it up on time, saw the banana peel and just ignored it. Damages refers to the type of recovery that the plaintiff is allowed to recover. So when we talk about damages, we think about money damages. For example, if you've lost some time off from work, or you also have some doctor's bills to pay. But we also talk about physical, emotional damages, and injuries to reputation are all different ways that somebody could be damaged. In tort law, we often talk about two types of damages. And I'll mention these again at the end of the PowerPoint if I have time. Compensatory damages are the types of damages that compensate or pay back a plaintiff for harms that he has suffered. So that would be what I already mentioned. If you have $5,000 in medical bills because somebody left a banana peel on the floor, you slipped and fell, and you had to go see your doctor, and you were charged $5,000 for the visits, then you, as the plaintiff, could recover that from the defendant. So compensatory damages, we like to include the out-of-pocket expenses, the out-of-pocket medical expenses. It can also include compensation for missed time from work, lost vacation or sick time, and even your pain and suffering. So if you have anxiety, maybe you've lost sleep because of the injuries, and you've now started to see a therapist, that would all be included in your compensatory damages. So what about punitive damages? Punitive damages are damages that are intended to punish a defendant for wrongdoing. So this would be a defendant who really goes out of his way to be negligent, sees all kinds of banana peels on the floor and just decides not to pick them up knowing that they would cause damage. More of what we would call the reckless conduct. And in the civil case, in civil cases, we don't send defendants to jail. So how do we try to teach defendants a lesson? Because we can't send them to jail in a civil case, juries can award punitive damages, those are when you start to hear about the multi-million-dollar tort cases, because that's really meant to punish the defendant for his wrongdoing. So both types of damages are available in the tort of negligence. All right, so let's talk about the tort of negligence. Negligence is a four-part test. So anytime you have a question in your mind as to whether a party acted negligently, this is the four-part test I want you to apply. Number one, the plaintiff must prove that the defendant had a duty of care. Number two, defendant must have breached that duty. Number three, the breach must cause the plaintiff's harm. And lastly, the plaintiff has to prove that he suffered some harm or injury. So anytime you see a tort question, tort of negligence, this is the four-part test to apply. So let's walk through each of these elements a little bit more closely. Number one, a plaintiff must prove that the defendant has a duty of care. So what does this mean? This means that every single one of us, as we are walking through and living our daily lives, we all have duties of care. The best example I can give you would be driving a car. When you get behind a wheel of a car, of course you have an obligation to follow the rules of the road, no speeding, no running red lights. That's the obvious part. But we also have a duty to be a safe driver. And safe driving means follow the rules of the road, keep your ears open, keep your eyes open, keep your eyes on the road. Don't drive and look down at something on your lap. If something falls down by your feet and you suddenly quickly look down to pick it up and cause an accident, that's not adhering to your duty of care. So everybody has these duties as we go about our daily lives. Some professions have special duties. For example, doctors have a special duty of care to follow the rules of the medical profession and provide standard medical care to patients. Homeowners have a duty of care. For example, if you invited me over to a barbecue at your house and you invited me to sit on your back deck, but you didn't tell me that your back deck had some loose steps, but you knew about it. You knew that the steps were loose. You knew they could cause an injury, but you just decided not to tell me. And I fell and got hurt at your house as a result. I could hold you responsible for that under a theory of negligence. What about businesses like Target, Walmart, Market Basket, or even Middlesex Community College? Of course, businesses have duties of care. Think about after a snowstorm. What is a business obligated to do? Well, the store has an obligation to reasonably clear the snow and ice so that it's safe for patrons and customers to come into the store. Could you imagine showing up to Target the morning after 2 feet of snow and the Target owners just sitting there shrugging their shoulders, telling you to bring your own shovel? Of course not. They have a legal obligation, a duty of care to reasonably clear the snow. So all of us have these duties. Now, to make this different from strict liability, I want you to realize that I've been using the word reasonable, and that is because the duty is one of reasonableness. Do we have a duty to be absolutely perfect? When Target clears its parking lot and sidewalks of snow and ice, does every little speck of ice have to be picked up? Of course not. That wouldn't be reasonable. But it would be reasonable to clear as much of the snow as possible, put down salt, put down sand, maybe put a sign that says slippery when wet or to be careful. That's the duty of care that we're talking about. So anytime we have a tort case, the first element is duty of care. The second element that makes it a tort case is that the defendant didn't fulfill this duty of care. The defendant had this legal obligation to clear, just to stick with the snow and ice example, to clear the snow and ice and didn't, or didn't do a reasonable enough job, maybe just kind of shoveled for like a few minutes and then left the rest and customers came and slipped. So we call that breaching the duty. And that means that the defendant failed to act as a reasonably prudent person would under similar circumstances. So for example, what would you expect someone to do when a snowstorm comes? Well, we would expect them to go out there as soon as it's safe to go and clear a reasonable amount of snow. So that's what we mean about failing to act as a reasonably prudent person would do under similar circumstances. Same examples with running a red light or medical malpractice. Medical malpractice is a word that describes the tort of negligence in the medical profession. If you come into the doctor's office complaining of stomach pains that aren't going away, the question of duty and breach of duty would be, what would a reasonably prudent doctor do under these circumstances? What tests would a doctor order? What scans would a doctor order? And that's the standard of care that we hold the doctors to. And if a doctor breaches that duty of care, that's where the tort of negligence comes in, and we call that medical malpractice. Okay, so now that we know about breach and duty, we have to talk about causation. This seems really obvious, right? That a defendant's breach of his duty has to actually cause your harm. So if I'm walking through Market Basket and I trip over my own feet, can I sue Market Basket for my injuries? Of course not. Market Basket didn't do anything to cause that injury. But if Market Basket left a slippery banana peel on the floor, or another, something spilled on the floor and it wasn't cleaned up on time, and then I slipped and fall, well, now we have the element of causation. So a defendant is only liable if his breach caused the injury. Here's the tricky part. We actually talk about two types of causation, actual and proximate. Actual causation, we call this the but-for test. Was the defendant's breach a substantial cause of the plaintiff's harm. So if Meg owns a convenience store, she sees a jar of jam crash and spill, but she doesn't clean it up because she's busy playing on her iPad. Tim comes in and he slips on the jam. Of course, Meg's failure to reasonably clean the jam spill would have caused Tim's injury. But for Meg's failure to do that, Tim was injured. I like to call this like a row of dominoes. The first domino goes down and knocks the others down, and we can draw a direct link between the defendant's failure to act, the breach of duty, and the plaintiff's injuries. That's the easy one. Here comes the harder question of causation. We call it proximate cause. This means that both the defendant's failure to act, meaning the breach of duty, has to be causally related or foreseeable that that injury that happened would have been the one that happened. I know that sounds a strange way to say it. So obviously, if someone doesn't pick up a banana peel on the floor, what is a foreseeable injury? In other words, what injuries do we think might happen? Well, somebody would slip and fall. That's foreseeable. But think about this, more attenuated hypothetical. Tim and Meg are driving separate cars, and Meg runs a red light. So what's the foreseeable harm if someone runs a red light? Crashing into Tim, crashing into another driver. That is foreseeable, and of course, Meg would be the proximate cause of that injury. But here's the tougher question. What if Meg and Tim both get out of their cars and they exchange insurance information while they're standing on the side of the road? All of a sudden, a freak summer storm comes through and a bolt of lightning comes crashing down and strikes Tim, and he dies. Is Meg liable for the death? Well, if you line up a row of dominoes, we would say, of course she's liable because she ran the red light. She breached her duty of care to be a reasonably safe driver. As a result, she crashed into Tim, so she was the actual cause of his injuries. And as a result, he died. Well, that's actual cause, but was Tim dying from this accident a foreseeable injury? In order to meet the element of proximate cause, the plaintiff would have to show that the injury that happened was a foreseeable injury. So what do you think? I think you can make an argument either way. Is it foreseeable that someone's going to get out of a car and exchange insurance information? Yes. Is it foreseeable that a storm might come and lightning would strike? Well, possibly not. So although Meg might have been liable for the original injuries to the car and any damage to Tim, she might not be liable for his death because that was not a foreseeable result of the car accident, her original negligence. One of my favorite cases about proximate cause is called Palsgraf versus Long Island Railroad. This is a fun little case where in the 1920s, a woman was standing on a train platform in New York waiting for a train to come. And all the way under the end of the platform, a train started going. And all of a sudden, a man was trying to get on the train, and he was carrying with him a package. So the train engineer or the conductor, I'm not sure, saw this man running towards the train and decided, let's lift this guy up onto the train and with his package, with his bundle, and then he'll make the train. So they do that, but as he's getting onto the train, the man drops his bundle, and guess what happens? It explodes. The man in his packaging was carrying dynamite. So, and the train conductor didn't know that. So the dynamite goes off and it causes a huge explosion. And this woman who's like about 300 feet away at the other side of the platform, some type of clock tower falls and hits her in the head and injures her. So she sues the railroad for negligence. So of course, the railroad has a duty of care. Did the railroad breach the duty of care? Possibly. But what about the causation question? Was the injury foreseeable? This was the case that said probably not. It really wasn't foreseeable that a man was carrying explosives in a package trying to get on the train. So the type of injury that she suffered was not foreseeable, and the train company was not liable. I have a couple more things to say about damages. So let me just pause the video here and see if I have enough time before I'm up on my 15 minutes. Okay, sorry about that brief video. This really just summarizes what I said at the beginning of the PowerPoint. The last element that is required for a negligence case is damages. We've got duty, breach, causation, and the two types of causation, and then harm. But we can't forget the harm. As I mentioned, if you don't have any harm, you can't sue for negligence. But harm can include money damages, physical injuries, emotional damages, crying, and it can also include damage to property. So like if your car has been damaged in a car accident. So those are the elements of negligence. Thank you for listening to this video.